An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Gideon versus Wainwright, 1963. The Sixth Amendment provides, quote, "In all criminal prosecutions, the accused shall have the assistance of counsel for his defense." In federal criminal prosecutions, the government cannot deny a defendant access to an attorney. In other words, the court cannot force a defendant to represent himself. That much is clear from the text. But does the Sixth Amendment also require the government to appoint and pay for a defendant's attorney? In Johnson v. Zerps, 1938, the Supreme Court held that a defendant in federal court who lacks counsel cannot be convicted, quote, unless he waives the assistance of counsel. And Betts v. Brady, 1942, stated that the Sixth Amendment, quote, requires appointment of counsel in all federal cases where a defendant is unable to procure the services of an attorney. Betts, however, limited that ruling about poor or indigent defendants to federal prosecutions. Betts ruled that state courts were generally not required to appoint and pay for a criminal defendant's attorney. This rule would stand for 2 decades. In Gideon versus Wainwright, 1963, the Supreme Court overruled Betts versus Brady. Abe Fortas, who represented Clarence Earl Gideon, recounted the facts of the case.
Clarence Earl Gideon, he was charged with breaking and entering the Bay Harbor pool room in Panama City, Florida. And having broken and entered that pool room, he is charged with having extracted some wine, perhaps some cigarettes, and a sum of money. At the commencement of the trial, the court asked Clarence Earl Gideon if he was ready to proceed. He said he was not, because he was without funds and without counsel. And he asked the court to appoint counsel to represent him.
The trial court judge declined Gideon's request. Under Florida law, the court could only appoint counsel in capital murder cases where the defendant faced the death penalty. Gideon told the judge, quote, "The United States Supreme Court says I am entitled to be represented by counsel." During the trial, Gideon represented himself, quote, "about as well as could be expected from a layman." The jury convicted Gideon, and he was sentenced to 5 years in state prison. Later, Gideon filed a habeas corpus petition with the Florida Supreme Court. He charged, quote, that the trial court's refusal to appoint counsel for him denied him rights guaranteed by the Constitution and the Bill of Rights by the United States government. The state court, in a ruling consistent with Betts v. Brady, denied all relief. Gideon then filed a handwritten appeal with the United States Supreme Court. It stated, quote, "I, Clarence Earl Gideon, claim that I was denied the rights of the 4th, 5th, and 14th Amendments of the Bill of Rights." The Supreme Court granted review and appointed Abe Fortas to represent Gideon. President Lyndon B. Johnson would appoint Fortas to the Supreme Court in 1965. The court unanimously ruled in favor of Gideon. Justice Black wrote the majority opinion. There were 4 major themes in this case. First, the court recognized that most defendants are unable to defend themselves in court. Indeed, prisoners who are unable to afford counsel are more likely to lack the resources and abilities to mount a defense. During oral argument, Chief Justice Warren observed,
"I suppose out of those 5,200 prisoners now in your jails who are not represented by counsel, that a vast majority of them are not only poor but are illiterate.
Warren asked Bruce Jacob, the lawyer for Florida,
If they're poor, just poor and illiterate, you think they always give them a lawyer in Florida?
Justice Black's majority opinion observed that, quote, lawyers in criminal courts are necessities, not luxuries. And if a, quote, poor man charged with crime has to face his accusers without a lawyer to assist him, then the courts cannot assure that, quote, every defendant stands equal before the law. This noble ideal, Black wrote, guarantees, quote, fair trials before impartial tribunals. But, quote, any person haled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. Next, the court considered whether the Sixth Amendment guarantees the right to counsel in state criminal prosecutions. The history behind this question is complex. Barron v. Baltimore, 1833, held that the Bill of Rights only restricted the federal government's powers. In 1868, the 14th Amendment was ratified. We discussed how many framers of the 14th Amendment's Privileges or Immunities Clause sought to prevent the states from making laws that abridged the personal guarantees of the Bill of Rights. However, in United States v. Cruikshank, 1875, the court held that the Privileges or Immunities Clause did not bar a state from violating the First and Second Amendments. In the wake of Cruikshank, the Supreme Court would find that the Due Process Clause of the 14th Amendment prevents the states from violating certain provisions of the Bill of Rights. The states could not deprive people of these specific fundamental rights. For the first half of the 20th century, the Supreme Court's cases were inconsistent. The court selectively determined that some rights were fundamental and other rights were not fundamental. Gitlow v. New York, 1925, quote, assumed that freedom of speech and of the press, which are protected by the First Amendment from abridgment by Congress, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. However, Palco v. Connecticut, 1937, held that the Fifth Amendment's prohibition on double jeopardy was not obligatory on the states. In Palco, the court observed that the Due Process Clause of the 14th Amendment protects those, quote, particular amendments that have been found to be implicit in the concept of ordered liberty. Palco explained that the Due Process Clause, quote, absorbed these fundamental provisions of the Bill of Rights. This so-called absorption process would later be referred to as the Selective incorporation doctrine. That is, the Due Process Clause of the 14th Amendment incorporated provisions of the Bill of Rights. Betts v. Brady followed the rule in Palco. The Betts court held that the, quote, appointment of counsel was not a fundamental right essential to a fair trial. The, quote, refusal to appoint counsel was not so offensive to the common and fundamental ideas of fairness as to amount to a denial of due process. 2 decades later, Gideon rejected this conclusion. Justice Black wrote that there was, quote, ample precedent for acknowledging that the Sixth Amendment right was fundamental. Since the founding, Black explained, quote, state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards. And these procedures were, quote, designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. In the court's view, it is impossible for a criminal defendant to have a fair trial and receive the due process of law without a lawyer. Gideon held that the Due Process Clause of the 14th Amendment secured a right to appointed counsel in state criminal prosecutions. The standard that governed federal criminal prosecutions would now also govern state criminal prosecutions. The court, however, was not unanimous on this point. Third, Justice John Harlan wrote a concurrence that was influenced by federalism. In his view, provisions of the Bill of Rights could apply differently to the federal and state governments. Harlan agreed with the majority that the right to counsel was, quote, expressly recognized as a fundamental right embraced in the 14th Amendment. But he contended that for an incorporated right, the court need not, quote, automatically carry over an entire body of federal law and apply it in full sweep to the states. Harlan explained that there is often a, quote, wide disparity between the legitimate interests of the states and of the federal government. The states and federal government, he wrote, face, quote, divergent problems, and their actions have, quote, significantly different consequences. Harlan expressed his view during oral argument. In Gideon, J. Lee Rankin represented the American Civil Liberties Union as a friend of the court. He explained that 45 states had already adopted rules to provide counsel for indigent defendants. This progress, Rankin said, shows that
the country has developed
since Betts. Justice Harlan said,
but that's characteristic and an example of the workings of our federalism at its best.
Harlan continued,
It doesn't take this court's decision to reform everybody in the United States or the states. They come to these things too.
Rankin replied somewhat impatiently,
I think it's to their credit that they have come so far.
Exactly.
But I don't think this court has to wait until the last one comes either.
Harlan interjected,
Maybe not.
The Supreme Court, however, rejected Harlan's position. And in a concurring opinion, Justice Douglas criticized Harlan's view, quote, that a guarantee of the Bill of Rights that is made applicable to the states by reason of the 14th Amendment is a lesser version of that same guarantee as applied to the federal government. Douglas observed that the, quote, rights protected against state invasion by the Due Process Clause of the 14th Amendment are not watered-down versions of what the Bill of Rights guarantees. Fourth and finally, the court turned to the question of precedent. Gideon did not ask the Supreme Court to overrule Betts. Rather, the court, quote, requested both sides to discuss in their briefs and oral arguments the following question: should this court's holding in Betts v. Brady be reconsidered? The court stated that, quote, Betts v. Brady made an abrupt break with its own well-considered precedents. For example, Powell v. Alabama, 1932, held that the Due Process Clause of the 14th Amendment required state courts to appoint counsel in capital murder cases or when certain special circumstances were present. Justice Black explained that Gideon would mark a, quote, return to these old precedents like Powell, which are, quote, sounder, we believe, than the new cases. And this return would, quote, restore constitutional principles established to achieve a fair system of justice. Ultimately, the court deemed Betts, quote, an anachronism when handed down and held that the case, quote, should now be overruled. Study guide. How does the majority consider the principles of stare decisis? Hint, the phrase stare decisis appears nowhere in the decision. In this landmark decision, the court ruled for Gideon and set a new nationwide standard for appointment of counsel. After a new trial, with the assistance of counsel, Gideon was acquitted.